Mr. Ramsden.
My Lord, thank you. I managed to distill myself to two further focus points on round 3. That's the Section 11A issue. And the first concerns the attempt by Mr. Malik, that really expanded in oral submissions this morning, to assert that because this was a New York Convention enforcement case, it falls outside the statutory exception. We say the answer to that can be found by looking at the English Arbitration Act and understanding fully how that would interact, we say, entirely explicably, with Section 11A. If we go to that, that's at electronic bundle page 1150, present purposes, Section 101 at 1151. I appreciate the court will be very familiar with this, so I'll take it very briefly, but we can see that the statutory...
Some are more familiar than others, so...
Even if we're familiar, I should take it quite slowly.
Okay. Understood.
Sorry.
Understood. So here we have the UK statutory recognition procedure acknowledging the New York Convention. So we can see in Section 101, subsection 1, the New York Convention award shall be recognised as binding on the persons as between whom it was made and may accordingly be relied upon by those by way of defence, by those persons by way of defence, set off or otherwise in any legal proceedings in England and Wales and Northern Ireland. And subsection 2, importantly, we say in this context, a New York Convention award may, by leave of the court, be enforced in the same manner as a judgment or order of the court to the same effect. And that was the point that my Lord Legate and my Lord Richards were canvassing in submissions this morning. Say it isn't a judgment as such, it's to be enforced in the same manner as a judgment. And we say, pausing there, it's important to appreciate that part of the statutory scheme when we come to Section 11A of the Gibraltar Act, which was to give equivalence to the award as a judgment. Now, what we say about the following provisions are that they are grounds or provisions, I say following provisions, in subsections 3 to 3 onwards.
Do you accept that there's nothing in the New York Convention that requires a signatory to include in its domestic law a provision along the lines of Section 101(2)?
So long as it's a signatory to the Convention, I don't believe it would.
So that's just something that the UK, or whatever the extent of this is, has put in itself?
Well, there is, of course, a distinction. I'm not sure this does answer my lady's question, but it comes to mind, of course. One has the procedure under Section 66, which is essentially domestic enforcement, and then you have the New York Convention procedure under Section 101 to 104, which is obviously foreign awards. One can posit that it was considered sensible by the legislature to cater for both, so cater for domestic and foreign enforcement in the one statute, in the Arbitration Act. But I think in direct answer to my lady's question, as long as you're a signatory to the Convention, then the award will be enforceable.
Mr. Ramsden, you're still developing the point, but so I can be sure I understand it. You're drawing a distinction between an award being enforced in the same manner as a judgment,
yes,
and an award
having equivalence.
Having equivalence.
So what we say is in Section 101 and 102, we see a procedure for the purpose of recognising an award under the New York Convention. And although it is different in parts, it is not hugely dissimilar to the process one would go through to recognise any judgment or award of a foreign jurisdiction in your domestic jurisdiction. So what the court requires you to do is to pass certain procedural hurdles here by statute, underpinned by the New York Convention, in order to achieve enforcement. But then in Section 103, and this is important, we say, to understanding the context of Section 11A, we see the grounds on which the UK court might refuse recognition or enforcement. And if we turn the page to Section 103 2F, and we say this is the answer to Mr. Malik's submission that Section 11A is irrelevant in this context. The award, this is one of the grounds for refusing to enforce, that the award has not yet become binding on the parties, or has been set aside or suspended or by a competent authority of the country in which or under the law of which it was made. Now, we say that that is, although in slightly different language, driving at exactly the same point that Section 11A is, namely, in order to have equivalence, it must be final and binding. In other words, it can't be subject to that objection under Section 103 2F. If that's right, if you start with the premise that the award is final and binding in its seat, if I use that shorthand, then Section 11A makes sense. And it is relevant to the question of New York Convention awards, contrary to the Rock submission. And we say the purpose of Section 11A, when regard is had to the enforcement regime under the New York Convention, it is simply to give equivalence to court judgments and qualifying arbitral awards which pass that threshold test. So finally, binding and enforceable according to the law of its seat. And of course, in turn...
But that doesn't automatically mean enforceable in the same manner as a judgment of a court in that seat. The fact that an arbitration award is final and binding,
of course,
doesn't per se make it enforceable in the same manner as a judgment.
No, it doesn't. It doesn't.
That's an additional requirement beyond.
Yes.
The net.
Yes. Yes, and if the requirements of Section 102 and 103 are passed, and there is no exclusion under Section 103, including, we say, relevantly 103 2F, then you are at play within Section 11A.
Yeah, but that depends on the Swedish law here, which is accepted that there is a provision of Swedish law which makes the award enforceable as a judgment.
Yes, that has been common ground, was common ground.
But if there hadn't been, then it wouldn't
Indeed.
qualify.
Indeed. So we say that really means that that Section 11A extends the meaning of, and I quote, judgment of a court in another country in Section 32AC to such qualifying awards. And that's how Section 11A drives into Section 32AC. That's why I think it is logical to deal with 11A first, because understanding that properly, one then has a better and clearer understanding of Section 32AC. As I observed,
just to clarify, or not to clarify, but just to confirm your position on the point we were debating before lunch, that
yes.
to a C, the reference there to the second reference to judgment goes wider than judgments which could be, or when it includes arbitration awards which are wider than arbitration awards which could be registered under a provision to which this is an exception.
Yes. Yes, I think that is an inevitable part of our analysis, but also we say correct. The answer is yes.
Because it couldn't be right that you could get in to enforce a Swedish an award made in a non-reciprocating country by virtue of 11A read together with 3.2.
Exactly.
Yeah.
And again, we say that is entirely consistent with what the ROC portrays as a rather stark statutory regime. We say not. It's a very clear one. You just cannot have parasitic judgments, whether, as I observed to Lady Rose before the shorter German, whether from recognised courts or not. You can't leapfrog from anywhere. You have to come directly as a reciprocating litigant. So that was all I proposed to say by way of emphasis on our written case on ground 3, on 11A. So let me move to ground 2, which is section 3.2ac, which again we say is understood far more clearly with the proper analysis of section 11A. Our headline submission by way of emphasis is that the 4 questions canvassed in our written case at paragraph 55, that is electronic bundle 1083, are really the correct sequential analysis in answer to how one properly understands section 3.2ac. And again, I appreciate the board will have read that, but just briefly by way of emphasis.
Which paragraph was it?
It is paragraph 55. Written case. That's page 19 of the key documents bundle in hard copy, and electronically it's 1083. And I'll take those 4 questions very quickly, but it's important to have them in mind and their logical sequence in mind. Is the High Court of England a recognised court? Yes, that is common ground. Second question, does Sweden fall within the meaning of another country in section 3.2ac? Well, we say again, yes, because that is the plain and natural meaning of the words.
I'm not sure that's a dispute either, is it?
No, I don't think after submissions this morning it was. So question 3 is, would the exception in section 3.2ac apply to a judgment of the English High Court in proceedings which have as their object the enforcement of a court judgment by a Swedish court? And again, we say applying the plain and natural meaning of the words, it does, and the answer to that again is yes. And we really don't attempt to do better than the analysis that Mr. Justice Yates set out in his second inter partes judgment at paragraphs 23 to 25. And again, that is in first bundle, tab 3, pages 30 to 31. So that brings us then to the equivalence provision, that is the relationship between section 3.2ac and section 11a. Does section 3.2ac properly construed apply in substantially the same way to arbitral awards made in another country, quote unquote? Well, we say by virtue of the deeming provision in section 11a, as we've already canvassed, it certainly does. The answer to that has to be yes as well. And so
provided they're qualifying arbitral awards.
Exactly. So we're familiar with that analysis, but we say it's important to understand the remainder of the ROC submissions. Now, we say that there is nothing special or unique about the fact the English proceedings were commenced pursuant to section 101(2) of the English Arbitration Act. I know we've just been to the Act in a different context, but it's important that I make reference to it for the purpose of this second ground. And the reason for that is that we say that there is no gloss to be found anywhere in the language of section 3.2ac, or indeed elsewhere in the Gibraltar Act. Section 11a, in particular, is drafted broadly, and it encompasses any qualifying arbitration, irrespective of whether it's a New York Convention award or not. We say that if the Gibraltar Parliament had intended to preclude any interplay between New York Convention awards and the Gibraltar Act, in the manner urged by the ROC, it could simply have made provisions similar to the exclusivity provision I drew your attention to in Section 8 earlier today, That's Section 8 of the Gibraltar Act. The equivalent is Section 6 of the 1933 English Act. Or it could very simply and easily have qualified Section 11A to exclude New York Convention awards, and that wasn't done. So we say that that effectively disposes of the argument.
It could be, wouldn't have to refer to New York Convention. It could say, apply to judgments in relation to an award in proceedings which are only enforceable in the law, under the law in force in the place where it was made, if it's been, if that court has stated or held or ordered that it's to be treated as a judgment, to limit it to cases where the arbitral award is only enforceable because of that step taken under the domestic
because of its equivalence
by the domestic court.
Because of its equivalence with the judgment, not for the reasons in the Gibraltar statute, but because there has been an enforcement application and it has been recognised. Yes. Yeah. But there was effectively no need to do that here, because the requirement is that the award is final and binding, and so long as it is final and binding in or according to the law of its seat, that is the threshold.
But sorry, just to take my latest example this morning and imagine that Norway does not have a provision that makes an award enforceable as a judgment under Norwegian law. Suppose then that these proceedings have been about getting an order under Section 101(2) to make the Norwegian award enforceable in England. What would you say about whether 2A(c) applies? Presumably it wouldn't.
Yeah, it wouldn't, because it doesn't fall within Section 11A, because it hasn't been declared final and binding in according to the law of its seat.
Well, then isn't it a more rational reading to read 2A(c) as confined to judgments which are founded on an award by reason of its characteristic as being an award which is enforceable as a judgment under its country?
With respect, no, for reasons I'll come to, because this is where, I think for the first time before the board, the interrelation between the exclusion in B and C has been canvassed, and we have something we say of relevance to say about that. Let me go straight to that.
Yeah.
So let's go to the Act, because this goes to the nub of the point. So if we go to electronic bundle page 1108, let us look first of all what is included before we come to the exclusions in A, B and C of Section 32A. What is included is under Section 3.2 a judgment of a recognised court which satisfies the following conditions. And we're concerned here with B. There is payable under it a sum of money, not being a sum payable in respect of taxes or other charges. So the relevance of that, not just as a matter of construction, but directly to this appeal, is that, of course, the ROC says and has to say that it comes within that provision. And it's not subsequently excluded. And I merely observe in passing that what is deeply unattractive about their argument on construction is that if they fall within Section 3.2b, as clearly as they say they do, it's very difficult to contrive a coherent reason why they're not caught by the exceptions. But be that as it may, there is a judgment of a recognised court for a sum of money. Now let's look at the three exclusions under Section 3.2a. The first is easy to comprehend, and one can understand that might apply to this board, for example. So we needn't spend too much time on that. The second, under B, we say is explicable by the provisions of the Civil Jurisdiction and Judgments Act of 1982, and it is an explanation which is different from the one that was canvassed with the board by Mr. Malik this morning. And although what was canvassed by Mr. Malik this morning doesn't, in our submission, get him home, nor does this, but we say, with respect, for better reasons or sounder reasons. Now, Section B was not focused on at first instance or on appeal, and Sir Colin Rymer did not say anything about the exclusion in B, less still reach any view on its proper meaning or construction. So this is the first time it's been dealt with. We had an inkling it might be, and so we had a look at the language in exclusion B.
On the face of it, it's a rather strange concept that a judgment of an English court is treated for the purposes of enforcement as though it was given in another country.
Exactly, and the answer to that is that this is founded in the Brussels and Lugano conventions. And a little earlier, we handed to the court usher Schedule 1 to the Civil Jurisdiction and Judgments Act 1982, which I hope makes this point clear. Thank you very much. I handed a copy of this to Mr. Malik over the short adjournment and explained our point.
Thank you.
We can see from the cover page that this is, as I just indicated, Schedule 1 to the CJJA of 1982. And it is, as the heading tells us, the text of the 1968 Brussels Convention as amended. We're concerned for present purposes, firstly with Article 26, which you will find on internal page 8. If we just mark that, and then secondly, with Articles 50 and 51, which appear on page 13. But let me just give a short prelude. The reason we alighted on this as an explanation for the drafting language is the very particular and unusual use of the word or other instrument in the exclusion of B. So a judgment or other instrument which is regarded for the purpose of its enforcement as a judgment of that court. And what we see in the Brussels Convention, and indeed this Act also incorporated the Lugano Convention, is precisely that language. So if we look at Article 26, a judgment given in a contracting state shall be recognised in the other contracting state without any special procedure being required. And we all know how that was developed in the treaties after the date of this First Amendment. But more particularly, if we then go on to the second reference, which is Article 50, we see first its title, Authentic Instruments and Court Settlements. And it says as follows: a document which has been formally drawn up or registered as an authentic instrument and is enforceable in one contracting state shall in another contracting state have an order for its enforcement issued there on application made in accordance with the procedures provided for in Article 31 et seq. The application may be refused only if enforcement of the instrument is contrary to public policy in the state in which enforcement is sought. And then in Article 51, interestingly, but also relevantly, we can see that a settlement which has been approved by a court in the course of proceedings and is enforceable in the state in which it was concluded shall be enforceable in the state in which enforcement is sought under the same conditions as authentic instruments, using that term again. We say that that is the much more likely explanation for the statutory language adopted in the exception in B. And it's an answer, we say, a complete answer to the Rock's submission that the exclusion in C is exclusively concerned with common law enforcement. It may include common law enforcement, but it also includes statutory enforcement. B is not concerned with the very wide ambit that the Rock contended this morning. B, in our submission, consistent with its very particular language and the recognition in the CJJA 1982 of the Brussels Convention, with enforcement which is more of an administrative nature under the Convention, and extends importantly to instruments as defined in that Convention. A European law, civil law concept, but not one as familiar to us in this jurisdiction, but entirely explicable if you read that section in light of the incorporation into the Civil Jurisdiction and Judgments Act, 1982, of the 1968 Brussels Convention. And we say that is the much more likely, plausible and logical answer to why the exclusion in B is drafted in the way it is.
So what exactly are these instruments contemplated here?
Well, not all civil law decisions are issued in the form of a judgment. So it can be a court declaration of which we would regard more in the form of a declaration, inter partes declaration in personam. I think we get a clue also from Article 51, my Lord, where we look at settlements approved by the court, for example, personal injury settlements approved by the court, which have the same force. So our understanding of that is that those decisions of the court, or those approvals, would be essentially entered in the court's register, and that is the, as we understand it, the instrument by which they become enforceable. But the word instrument has absolutely no meaning either under the common law here, statute here, apart from its use in this exclusion, and correspondingly in Gibraltar. Now, although as I'm sorry.
You referred us to Article 26, but I just wonder whether it isn't Article 31 that is more important, because 2AB is talking about enforcement, not recognition. 26 is concerned with recognition.
Yeah.
31 is concerned with enforcement. Your reference to 50 is to enforcement of an instrument, so that seems to be.
And anyway, 26 doesn't result in an English judgment.
I mean, B is.
No, it results in enforcement.
Yes,
Absolutely.
of a foreign judgment.
Of a foreign judgment, indeed. Indeed. But my Lord, the
31.
Yeah.
Yes, so 31, as my Lord says. So you might register your French judgment in England under the pre-Brexit provisions.
Yes.
And then you might say, well, I've got this. But then you would say that 2AB is saying, well, that is what's referred to as a judgment which is regarded as a French judgment.
Yes.
That you're trying to enforce. You can't come along and say, well, because I've registered my French judgment in England, I'm relying on an English judgment.
Exactly. It's not an English judgment.
And B is shutting that out, making it clear that it counts. It's a French judgment.
It's a French judgment.
Treated as a French judgment,
Yes.
and therefore outside the reciprocal provisions.
Indeed. And if by the relevant convention, treaty, or statute, you can make that enforceable, so be it. But if you can't bandy it around as a judgment. Absolutely. So, my Lords, may well be right.
How does that influence your reading of C?
Well, our reading of C is therefore much clearer, because what we don't have is the rather anomalous and we say odd restriction that the ROC places on it, that C is just common law enforcement. C is everything else. So C is statutory enforcement, which may include statutory enforcement of a New York Convention award. It may involve enforcement of a judgment under statute. It can also include common law enforcement. So it includes all of those things. And when one understands the exclusion in B properly, we say, and matter for the board in due course. But if you accept my submission as to the correct meaning of the exclusion in B, then C would logically include everything else.
Everything else except the civil jurisdiction and judgment, say?
Except that.
Yes.
Absolutely.
So it would include both limbs of section 101, both the
Yes.
a judgment entered in terms of the award and an order that you can enforce the award in the same manner as a judgment.
Yes. But the only condition is it cannot be parasitic in the way we canvassed before the short adjournment.
But in 101, subsection 1 and 3, or 2 and 3, which seems to distinguish, do you say that both those are judgments for sums of money? Oh, sorry, we were looking at it.
Yeah, my lady, I think it comes back to the same point as whether the judgment of Mr. Justice Burton is relevant. We say to this bill it isn't, because it's the costs orders that are sought to be enforced here.
Yes, but if you go back to the bundle at 1151, look at 101. So you've got 101.2 that says the award may, by leave of the court, be enforced in the same manner as a judgment.
Yes.
And then you've got 3, where leave is so given, query whether that's referring back to 2 or referring onwards, where leave is so given, judgment may be entered in terms of the award. What does that mean then?
Well, it means that the award has become enforceable as a judgment.
No, that's with respect to 2, but then you can actually get a judgment.
You can get a judgment.
Yeah. Get a money judgment. In the same
money
terms
judgment.
as the
Money
award.
judgment. So what we were exploring with Mr. Mallet was whether anything turned on which of those you ended up getting at the end of the day.
No.
Well, why do you say it doesn't turn on?
We say not, because we're concerned here with the money judgment, and the same analysis would apply if it was a non-pecuniary obligation imposed by the judgment. Of course, the qualifying, I think the answer is the qualifying requirement for inclusion before the exclusion operates is that the judgment is for a sum of money.
Right.
And so you're always talking here about money judgments. We said the fact it's costs is irrelevant. It's a money judgment.
Yes. So if it was just an order in the terms of 101.2, that may or may not be a money judgment, and if it isn't, then it's not enforceable at all.
No.
But if that is to be regarded as a money judgment, and certainly if you go so far as 101.3 and get your judgment entered in terms of the award, so it's an English court order for $500 million, whatever it was, then you say, well, now it comes within 3.2, but it's not enforceable for, or not registrable for other reasons.
Yes. Because of C.
Because of C.
Because of C, yes, exactly. And in that way, my lady, the statute works perfectly well, seamlessly and comprehensively.
I find 2AB still quite puzzling in its language, because it refers to a judgment which is regarded for the purposes of its enforcement as a judgment of that court. That doesn't really fit with Article 31 or 50, does it? Because that doesn't regard the French judgment as an English judgment.
Made in France.
Made in France.
I mean, it regards it as it's registered for enforcement.
Yes. Yes.
It's very hard to imagine that there ever is a situation in which a judgment of an English court is regarded as made in France or another country.
Indeed. Indeed.
For the purposes of its enforcement.
Yeah.
Oh, the way I read,
I don't know whether those
if I may
words-
say so, is this, that the following judgments of a recognised court are not within subsection 2. a judgment or other instrument which was given or made in another country,
Yes.
which
I
is
see.
regarded for the
I
purpose
see.
of
Which
is
its enforcement
Oh, I
as
see.
a judgment of that court, being
Okay.
recognised.
Yeah.
for.
And,
Oh,
and
right, so that does make sense.
that's the French example.
Yes.
Yes. So
It works.
you've got a French judgment which pre-Brexit you wanted to enforce in England. You had to register it on application to the court.
Yes.
And I think registration might be, certainly under 50, could be refused on public policy grounds, but only public policy.
Only public policy grounds.
But that's an odd way. It's not regarded for the purposes of enforcement as a judgment of the English court. It's registered as a French judgment for enforcement in England.
Yes.
So why does it... This is very convoluted language.
Well, it may be that different countries do it in different ways, and they wanted to use some broad wording that didn't tie it to how England does it, because there are lots of different ways of doing this.
But in that case, why does an arbitration award not come within B? Which is on application made under 101. I mean, what's the... I don't really understand why an application under 101 2 isn't within B. I mean, I can see an argument for saying, because these provisions were brought in by the CJJA Act of 1982. So
Yes.
it's sort of very a sort of obvious thing to read them together, or to think you should read them together. But then one's left with the startling point that quite different language is used, which makes one query whether it's meant to be simply a mirror image of what's in what was in the Brussels Convention.
Yes.
And if my lady is right, that it's sort of casting a wider net, well, why is the net not wide enough to include the arbitration award, for which enforcement is sought under 101(2)?
I think that, again, the most plausible and logical explanation for that is that the exclusion in B, as I indicated earlier, has the characteristic, that is, it is addressing something which has the characteristics more of an administrative function. So you register your judgment, your French judgment. It becomes enforceable as a French judgment in England. C is concerned with the much more substantive recognition proceedings, and hence uses the words proceedings. And, my Lord, I think I would be reinforced in that submission, because B does not use the word proceedings. So the way we look at this is that B is a more administrative procedure. C, specifically using the term proceedings, is the substantive enforcement, the substantive recognition and enforcement of a foreign order or judgment. My Lord, I entirely recognise your point in relation to the breadth of the language, and if I may say so, I think my Lady Rose's observation is probably the answer to that. This legislation, in fairly short form, had to take account of an extremely broad jurisdiction under Brussels and Lugano, and sought to do so by casting its language very widely. But it doesn't change the essence, the nature of the exclusion in B, as I've characterised it. I don't think I can put the point any better. I think that's how we distinguish B and C.
Yes. Thank you.
And as I say, if that is right, the board accept that. It's an end to the ROC's argument completely, because C would cover the kind of enforcement that we are concerned with here. And if we're right about the fact that the objection is merely to parasitic enforcement, if I put it in that short colloquial way, then the exception applies, and the Court of Appeal were absolutely right. Now, my lady, the board doesn't necessarily need to reach a view on what the exclusion in B means, because it's not strictly speaking before it. But that's not just an idle submission. Actually, I think it probably could, because I think it is clear enough what B means, and I think understanding B helps one understand C, unsurprisingly.
If someone came with a Canadian judgment to England and registered it under the equivalent act to this, You would say that was not an administrative procedure, but proceedings?
Under C, yes. Yes, yes. Because the Brussels Convention and Lugano provide for a mechanism, as we saw in the first quotation I gave you, without any special procedure is the language used. So you have an automatic right to come and register.
To register, but you do have to do something.
You have to do something. You have to do something, but what you don't do...
You have to make an application.
Yes.
Is that right?
No.
When on application of any interested party.
Under this
Under
regime,
31.
Yes. Yes.
Under that regime you do, but you're not required to engage in proceedings of the kind that you would for other kinds of enforcement.
If an application were made under, let's say, Article 50, which is the instrument one you've
Yes.
showed us, and the application was opposed by the judgment debtor, or the instrument debtor, shall we call it, on grounds that it was contrary to public policy in England, and succeeded, and obtained an order for costs. That the B would not exclude enforcement of that order for costs under this Act, would it?
So long as you're dealing with reciprocating countries, and so long as there is no parasitic element to that. So yes, if it's direct between reciprocating countries.
That's a difference. Maybe that's one of those things. Maybe, but that's a difference between B and C.
Yes, one of the differences. Yes.
I can't understand at the moment why there's a difference as to whether it falls under B or C between a French judgment registered under the CJA and a Canadian judgment registered under the 1933 Act. They both require an application to register in order to enforce. And I don't see why one should come within B and the other within C.
The answer is, I think, the French example is, of course, governed by the Brussels Convention. And
Sure.
so the grounds there, as we know, are much narrower. They're very, and indeed the grounds for objecting is only on grounds of public policy. So insofar as there is a difference, I think that is it. There may be circumstances where there is no discernible difference between the two judgments in terms of their quality or enforceability, but in terms of how you enforce them, CJGA incorporated the Brussels Convention, and that is a very summary procedure. As I say, on our explanation, it's impossible to get away from the use in the exclusion in B of the term or instrument, because that isn't something that we in this jurisdiction.
No, so it's evidently meant to encompass a French judgment or instrument, but that doesn't show that it doesn't also encompass, let's say, a Canadian judgment or a Section 101(2) award, all of which could be regarded as administrative procedures, if you like, which don't require you to actually issue proceedings like you do if you want to enforce a common law. You have to issue a claim form and bring proceedings. That's the whole point of these sorts of regime, that they cut out that you don't have to bring proceedings in England. Or
Indeed. I mean, there may be instances where there is an overlap between the two, but it seems to us that B is very specifically aimed at the European, principally at the European regime, and in particular the Brussels Convention. But we say what there is absolutely no warrant for, whether on the analysis I have just advanced or on the wording of the statute, is that Section 32AC is limited to common law enforcement and excludes either New York Convention or any other statutory enforcement, as I understood the ROC submission. It's purely concerned with common law. Now, though there was at times a retreat from that position during oral submissions, that's very much the ROC's case in writing. So that's how they explain why they're not caught by the exception in C. And if all of that is right, I can deal with the other points in relation to the costs order briefly. As I indicated just after...
Can I just ask you this? I'm sorry. Would you say that would you say that a judgment could come within both B and C, or put it this way: you've got an application made under the Brussels Convention, as it then was, which could be opposed. I mean, on one view, I mean that's within B, you would say, if the judgment is registered, or whatever the word is. But nonetheless, under C, the application that is made, which is made to the court, as far as England is concerned, or the UK, are proceedings founded on a judgment of a court in another country.
Yes, and
So it would you would say it would encompass the costs orders made in those proceedings.
Yes, of course.
So B and C are not necessarily mutually exclusive.
No, they are not. But they address two quite different processes. I mean, using the Canadian example again, if the applicant was able to register their Canadian judgment without the issue of proceedings, they'd fall within the exclusion in B. If, however, for whatever reason, they had to issue proceedings to do so because of the particular circumstances of their case or the opposition to registration and enforcement, they come within C.
Yes, but B, even a Brussels Convention enforcement requires the issue of proceedings, because you've got to make an application.
Well, you make an
application,
Which depends what proceedings means, doesn't it? Does it mean an action? You have to bring an action, or,
Yes.
or does an application under the Act count as proceedings? That's what we're discussing here.
That's the point. And we say clearly an application is not
Yeah,
proceedings.
but really? Proceeding seems to me as wide a word as you could possibly have for something that happens in court.
Well, proceedings could encompass that, but proceedings are a fully pleaded and tested.
Well, that includes it, but proceedings also includes an application where there is no respondent at all.
Well, it may, but there is a difference between issuing a claim form with a pleading to enforce a judgment and merely making an application under the Brussels Convention to register your judgment in circumstances where, absent public policy objection, you have a right to do so under the Convention. That I think is the distinction.
Okay. So you're saying that an application made under the Brussels Convention are not proceedings within C?
I think that's right. They fall within B.
But an application under Section 101 of the Arbitration Act are proceedings within C?
Yes.
And what about an application to register a Canadian judgment under the 33 Act?
Well, again, the example I gave a moment ago, where that could fall within either, depending on how the enforcement ensued. So if it was done by mere application under the 33 Act, and, for example, there was no opposition, we'd say that falls within B. But if it was necessary to issue proceedings in the sort of common law, conventional sense of common law enforcement, then that would be C. And one can understand why the legislature had done that. We submit that they're primarily focused on the convention.
I'm getting very lost, because I thought it was your case that C was not confined to common law enforcement.
It isn't at all.
So
You seem to be oscillating a bit on this point.
Well, I'm sorry.
If I may say so.
In which case, that's entirely my fault if I haven't been as clear as I should have been. Or the point I was making, and I may be making it slightly clumsily, is my Lord's example, there may be circumstances where a Canadian judgment is registered in this jurisdiction by simple application. There may be circumstances where that is not possible because of the nature of the judgment or the nature of the opposition to its registration and enforcement. And in those circumstances, it would be necessary to issue proceedings. And of course, it's important to remember that registration, as we understand it, under the Brussels Convention and Lugano, is founded on a certificate from the issuing court. And that simply confirms that the requirements for registration have been met.
Yes, but you still have to make an application.
You have to make an application, indeed.
Anyway, perhaps the best thing is, just to conclude this, as far as I'm concerned, tell me what you say is within B, and tell me what you say is within C.
Yes, indeed. So under B, we are concerned with the registration of judgments by what I characterised as an administrative act. So that is the obtaining of a certificate from the issuing court that confirms the requirements of that court have been met. And we say that an application under the Administrative Justice Act or the 1933 Act is effectively an adjudicative act.
So, I mean, with respect, I think it's what happens. I mean, take our case of the French and English judgments. It's not what you get from the French court that matters. It's what happens in England.
Yes.
So what is within B that happens in England?
So within B, one produces the certificate from the issuing court.
Under which legislation are we to? What legislation is B aimed at, would you say? Well, I suppose you would say anything which only has an administrative act.
Indeed, it's the Brussels Convention.
Automatic.
Yes. So the Brussels Convention, under Schedule 1 to the 1982 Act.
Yes, so Brussels Convention, Articles 31 and 50.
Yes.
And it's, yes, okay.
And of course, Lugano.
Oh, and Lugano. Yes. And C would include, well, obviously common law enforcement, but also 1933 Act.
Yes.
Or 1920, 1933.
Yes.
And Arbitration Act.
Yes. So it doesn't exclude statutory enforcement as the ROC.
Okay. Thank you.
I'm sorry if I was a little.
No, that's very helpful.
That's very clearly and squarely the way we put it. My lords, my lady, very briefly in relation to the further points which were not pursued with any great enthusiasm, if I may say so, in oral submissions, that in some way the discontinuance of the English proceedings in some way makes a difference to whether the costs orders that followed were part of the proceedings. We say plainly they were. They arose out of the proceedings. As was pointed out earlier, the Court of Appeal judgment effectively permitting the discontinuance was part of those proceedings, and the costs orders followed from their discontinuance. So we say there is no disconnect there. And the point I made earlier in relation to whether the costs orders can in some way be detached from the proceedings such that they are not to be regarded as part of the enforcement proceedings in this jurisdiction is, we say, equally tenuous and unsustainable. For the reason I indicated earlier, because it is the ROC's case that the costs orders fall within section 3.2, so 3.2b, so that they are a money judgment of the English court. And we say that money judgment can only have followed the proceedings for the enforcement of the award in this jurisdiction. And it's for those reasons, we say, that applying the proper and sequential analysis, both of Section 11A and Section 3.2CA, this appeal should fail for substantially the same reasons it failed in the Court of Appeal of Gibraltar.
Just want to go back to the Norwegian example, if we may. The hypothetical Norway, anyway, I'm sure it isn't actually true in Norway, that you can't, that an award there is not enforceable as a judgment under Norwegian law. But they come along to England and they try and get the Norwegian award enforceable in England, and there's a costs judgment. Like everything exactly as here. does Section 2AC protect you in that situation against enforcement of the cost judgment in Gibraltar?
So just to be clear, there's an attempt to enforce the Norwegian judgment in this jurisdiction.
Sorry, in England.
In England.
Everything happens as it did in real life.
A Norwegian arbitral award.
Yes, a Norwegian arbitral award, except instead of a Swedish award, it was a Norwegian award. And everything then happens as it happened in real life. And they were arguing about whether the costs orders made in the English, on the English application are enforceable in Gibraltar. And I'm wondering whether, in that situation, you say that 2AC insulates from enforcement, or it doesn't.
Well, sorry, just Mr. Kuhn, so we think the answer to this conundrum is in the commentary from Hill and Chong, International Commercial Disputes, and that is authorities, electronic page 1765. Those in hard copy, that's tab 22, and it's the passage at 24.6.8.
Passage at, sorry?
It's paragraph 24.6.8, under the heading, the effect of a foreign judgment on the award.
I really haven't understood the point.
Can I just make the point I have in reliance on that? We say that Section 11A is concerned with finality, and it is not concerned, it does not look at the law of the seat. So using the Norwegian example. So
the Swedish provision, which is mentioned in the judgment at first instance here, is irrelevant in your submission?
No.
Right.
No. What Section 11A is driving at is the judgment, in this case the award, final and binding. That's the touchstone, and it isn't required. There's no requirement, nor in practical terms could there in our submission be a requirement to involve oneself, interrogate the law of the seat. So long as under the law of the seat, the originating jurisdiction, the judgment is enforceable.
That's the point, isn't it?
That's what Section 11A is concerned with.
Yes, which is the paragraph you've referred us to. That's the first sentence.
Yes.
It is dependent on the award having become enforceable under the law of the seat. And that's what Section 11A says.
Yes, and that's what Section 11A's focus is. I'm sorry,
Exactly. Well, that's my Lord's point, though, because in the Norwegian award example, it's not enforceable as it's not enforceable under the law of the seat as a judgment.
There's no equivalent in Norway of that provision in the Swedish law that's mentioned by Mr. Justice Yates.
Maybe it is.
It's the words that matter are not judgment. It's final and binding according to the law of the seat.
No, that's not. Sorry, that's not what Section 11A says. Section 11A says, has in pursuance of the law in force in the of the seat, effectively, become enforceable in the same manner as a judgment.
In the same manner as a judgment, exactly. In the same manner. That's my point.
Yes.
Well,
It doesn't have to be.
So I see. So you're not. So perhaps we've been, maybe my fault, set a hair running which doesn't exist, which is that it's not looking at some additional procedure that has taken place in Sweden, which couldn't take place in Norway. Norway may not have that procedure or anything, but still, the arbitral award is regarded as enforceable
Yes.
in Norway.
Yes. Yes.
But not necessarily enforceable in the same manner as a judgment.
Well-
It might just be
Well, my lord, with respect,
there may be means of enforcing a judgment that don't apply to an award.
and well, that's the reason. The language of the statute is in the same manner as a judgment. It doesn't have to be one.
No, it isn't. No.
And my lord, the point is, of course, that language is the same as in the Arbitration Act. So
I know, that's why we're interested in
yes,
the point.
and that's it. So no, I mean the point that my Lady Rose just made is our point.
But if you look at 2469 on page 1765, it posits the award may have become enforceable by a summary procedure, for example, by deposit of the award with the court. That's a kind of administrative act, maybe.
Yes.
Secondly, the award may have been converted into a judgment by a procedure analogous. But I think what you're saying is that 11A covers both of those.
In paragraph 33 of the judgment of first instance here, which our attention was drawn to, and it was discussed, it was common ground, there's a reference to provision of the Swedish Enforcement Code.
Yes.
What I'm interested in is, does your argument depend on the existence of that provision, or would you say if Sweden had no such provision in its enforcement code, that wouldn't matter for the purposes of your argument?
The recognising court has to be satisfied that the award is final and binding, and that might be via an enforcement code or otherwise. But the key is it needs to be satisfied that it's final and binding. And
Well, that's not what 11A says. It doesn't say you have to be satisfied it's final and binding. It says it has to be in pursuance of the local law, enforceable in the same manner as a judgment given by a court in that place.
well, my lord, to get to that point under section 11A, it needs to be final and binding.
Well, it does. It's a condition that's
Yes.
necessary but not sufficient to satisfy 11A. Final and binding wouldn't be enforceable in the same manner as a judgment if it wasn't final and binding, but the fact that it's final and binding doesn't mean that it's necessarily enforceable in the same manner as a judgment.
Our submission is, of course, that whole structure, that language comes from having already satisfied the conditions that get you into section 3 before you get to the exceptions. So,
Not in your case, because you're saying that the exceptions have a wider ambit than the provisions that get you into them. That is part of your argument, is that we're not concerned in section 3.2 itself with the possibility of enforcing a Swedish arbitration award, because there's no reciprocation between it with Sweden.
that's right. But of course, whatever it is that is enforced in the reciprocating country, in England, has to be based on a final and binding entitlement. And again, to be enforceable as if it were a judgment, not necessarily as a judgment. Doesn't have the status of a judgment. So we don't have to focus, let's still fixate on the word judgment. It's enforceable as if it were.
In the same manner as. Yes.
In the same manner as. So I'm sorry. Yes. Slightly different language.
So sorry. Is your answer to my question that it wouldn't matter if Swedish enforcement code didn't exist, and this were the Norwegian if that's the counterpart that we're imagining.
It is difficult. It's difficult to answer that now because we would need to be satisfied or the Gibraltar court would need to be satisfied that that condition was met, absent the Swedish Enforcement Code. And of course, the Swedish Enforcement Code has been accepted as applying. There is no dispute that this is a qualifying judgment. So the hypothesis my lord puts to me doesn't arise. It didn't arise before. The Gibraltar court would have to satisfy itself of that.
So your answer is that if it weren't for the Swedish Enforcement Code, then you wouldn't be able to rely on Section C? Yeah.
Well, in this case, no. In this case, no. Because that's how it's been. That is how it has achieved the status it has. Judgment, but there may be other cases where that.
So we could have a Norway case which was exactly parallel to this case. Everything happened exactly the same way, and the costs order would not be shut out by little c because the relevant arbitration award, which founded the whole proceedings, was not one that satisfied 11A. And in that situation, although it was a Norwegian award, a third country award, the costs orders made in successfully opposing enforcement in the UK would be enforceable in Gibraltar.
Well, my lord, my answer to that is the point I made earlier, that one still has to be satisfied that the award is final and binding. So the Gibraltar court would still have to look at the Norwegian
proceedings. You keep coming back to that, but what I want you to answer is whether, in the case we're positing, where the Norwegian award, let's assume, is not enforceable in the same manner as a judgment, Section 2AC applies or it doesn't apply. It's a simple question, and I just want to know whether your answer is yes, it applies, or no, it doesn't.
If it's not enforceable as a judgment, then no.
But what does
it doesn't, that mean?
Right. Does that mean, I thought that when it's talking about enforceable in the same manner as a judgment, what it's talking about is that then the whole might of the state can be brought to bear on the person who doesn't pay what they're supposed to pay. That is what the purpose of judgment is, that you bring your proceedings, and when the court has made an order, if you disobey it, it's not now just a private matter between the two of you. The state takes it upon itself to enforce it because that's what the rule of law requires. So I think the answer may be that whatever happens in Norway, whatever law they do and don't have, if actually the result is that you can call upon the state to injunct the sale of their property or make them, I don't know, the writs of enforcement or whatever, send in the court officials to seize their belongings. It's that they're talking about. It's that it's no longer just you asking them for the money. The court is saying you have been ordered to make this payment in a manner that we recognise, and we will make sure you do.
Exactly, and where there is no enforcement code in that country, then it would be up to the court asked to enforce or recognise and enforce the judgment to satisfy itself that that is the case.
It's not so much that it's final and binding, it's that it has now moved from being just a debt, which is the job of the judgment creditor to enforce, to it being the business of the state to enforce it as well.
Yes, it's acknowledged as an obligation that must be met by someone other than the holder of the judgment.
Yeah.
That's probably the simplest way I can express it. And that's what it's driving at. That's what Section 11 is driving at. And if that is right, it works in the way we submit.
Because if you just have a private arbitration and the arbitrator says, all right, you owe £1 million, there's nothing I can do to get the state to help me get that £1 million. There has to be some other mechanism to engage the powers of the state to enforce it. I think that's
Yes.
how that's done in any particular country may...
Of course, if you wish to have the assistance of the state, you need to invoke it, yes.
Mm.
So, my Lord Legate, I hope I have answered your question.
Well, I take your answer to be that it's possible to have an award which, because it's binding, you could seek to enforce in England under the Arbitration Act, but which would not be caught then by proceedings based on that award in England would not fall within the exclusion in little c, because the award is not enforceable as a judgment under the law of its seat.
Conceptually, that is absolutely right. But when we look at the arbitral enforcement regime, we ask the question, in what practical circumstances would that arise? I think that's my point. I didn't mean to evade your answer, but I was struggling to comprehend circumstances where that would happen. And the fact is, I don't believe it would. And when this legislation was drafted, it would be perfectly right for the board to infer that that was something that the drafter did not either have in mind, or if they had it in mind, they did not regard that as a likely problem that this legislation would need to address. I think that's, my Lord, I think that's the best way I can put it. So, my Lords, my Lady, unless I can assist further, those are my submissions.
Thank you, Mr. Ramsden.
Thank you.
Mr. Malik.
My Lords, my Lady, I think we covered a lot of the points in discussion. I mean, where we are at the moment is that we've got these cost orders which are clearly covered by the Act. So essentially the states have agreed we will recognise certain types of judgment and this meets them. The only question then is, do we lose, as the courts below have held, on the basis that this exclusion in 3.2 AC is applicable? We say no, it is not in play. It is not in play because behind all of this is, again, an agreement that we are now going to extend to certain arbitration awards, not all arbitration awards, the same way that we treat as judgments. So there's an extension into awards. The question is, what awards are we going to cover? And the awards we're going to cover are those that are set out covered in 11A, which are essentially qualifying awards. But, as Dyson Morris makes clear, we're talking only about English awards and not awards by states who are not parties to the treaty, who are not reciprocating. So the short answer, therefore, on that first point is that we are outside this. The section does not apply because we're not dealing with an English award, we're dealing with a Swedish award, therefore the exclusion doesn't apply. We're then left with the second argument, which is the question of whether or not we are caught, because we are, although we are the decision of a recognised court in terms of the awards, we're taken out because we're using the language of 3A 2C, we're talking about founded on a qualifying award. We are not founded on a qualifying award. A qualifying award that doesn't form any part of the analysis in terms of the claim, the proceedings, in other words, the commercial court proceedings. It's not an element that needs to be established under the Arbitration Act, and therefore the existence of the qualifying award under Swedish law is of interest. It's a matter of history, it's a matter of fact, but it has no legal relevance. Now, the only way that my learned friend can get around that difficulty is to do as he did earlier today, which is to say, well, the Arbitration Act provides as a get-out in terms of non-recognition a certain type of award, which is the point about F. And if we can just get that on the screen, it's the Arbitration Act, section 101. If I can get the page number.
1152, I think.
1152, yeah. And therefore, the award has not become binding on the parties or has been set aside. Now, that is in my submission, totally different from Section 11A that we looked at a moment ago, or several times today, multiple times, because it's not within the provision in terms of has become enforceable in the same manner as a judgment given by the court of that place. This is dealing with a position where, as I said, the award's not binding or it's been set aside. It is a different test. There is no requirement, and I come back to my first point, there's no requirement in order to get this New York Convention award registered that this requirement of a qualifying award as a matter of Swedish law needs to be satisfied. So my respectful submission, the reliance on 2F here isn't an answer to the problem that undoubtedly exists here, which is that the existence or not of this as a qualifying award is we say is actually essential. That it is not. The question is whether it's qualifying or not is irrelevant in my respectful submission, and therefore the claim on that second limb fails as well. Now, the only other point I wanted to make in reply was the point about B in 3.2a, B and C in terms of what they cover. And if we can just remind ourselves what was said by my learned friends in their written submissions, because this isn't something that's come out of the blue. If you can turn to their written case at paragraph 24, which is in the key bundle at 54, but in an electronic bundle 1076, they say that at the bottom there, it is common ground, the exception in 3.2a.
Sorry, could you just give me the reference again?
Yes, it's paragraph 24 of their written case.
Thank you.
And what they say is there, common ground that's 3.2a, dealing with, for example, with appeals for the Privy Council, etc., etc. And this is the bit, 3.2ab, excluding registration of judgments given or made in a third country which have been registered in a recognised court and which have the same effect as a judgment of the recognised court do not apply to this case. And that's essentially, if we then turn back to what the difference is between B and C, and for that purpose, if we can look at 3.2a, B and C and get that on screen, you'll see that B is really concerned about foreign judgments that have been treated as domestic judgments, whereas C is about domestic judgments founded on foreign judgments. And that may be for the reason as a matter of common law, or it may be a matter of statute. And that's clear in the papers accompanying the notes to the Act, where that distinction is made. So in my submission, the analysis on B and C is exactly that. It's about foreign judgments treated as domestic judgments, whereas C is about domestic judgments founded on foreign judgments, and therefore it is possible to give content on that. So then the only other point I wanted to make in terms of reply submissions is...
So what does B cover? It would... Obviously, it would cover a French judgment,
correct,
but it would also cover the Canadian judgment,
yes,
registered under the 1933 Act.
Correct.
And
That's
it
right.
would cover, if it includes awards, so far as it includes awards, it would include an award enforceable as a judgment under Section 1012
yes,
of the Arbitration Act.
Correct. Okay. Accept that. And then the only other point I wanted to make is just to stand back and say that we are dealing with an exception where, for public policy reasons, we have an objection to judgments on judgments. But that's not our case at all. There's no question, there's never been a risk of any kind of judgment or award laundering in circumstances where our entire case is that this case should never have been brought in England, that it was a fraud and contrary to public policy. And therefore, if one stands back and says, is there any circumstance in which this could amount to judgment laundering or ward drawing, the answer is clearly no. And my lady, that's all I wish to say by way of reply. Thank you.
Could I just for the sake of complete clarity, could I ask you please to go to paragraph 55 of the respondent's written case? Paragraph, which was the not
Four questions.
Four questions. So, question one, that's obviously a common ground, and there's no question about that. But I think you can't accompany a question two, is that right?
I'm not sure about that.
No, we don't have a
This is another country, isn't it?
Yes.
Another country, all right. Sorry, I perhaps was leaping forward. But when you come to apply it to the... So is it... it comes at 4 then? So you haven't a problem with 3, is that right?
Would the exception apply to a judgment of the English court in proceedings which have as their object the enforcement of a court judgment by a Swedish court?
Answer yes.
Yes.
I would agree.
Yes.
So it's only 4 that
It's 4.
Yes.
all the issues come under 4.
Exactly.
Yes.
Yes, and there you say no for 2 reasons. One, because 11A doesn't apply, and also, even if it does, it's not founded on, the proceedings were not founded on that
That's correct, my lady.
arbitral award.
Thank you.
Thank you.
Mr. Malik, Mr. Ramsden, we're very grateful to you both and to your juniors for the presentation of the oral arguments and indeed the written submissions, which have been very helpful. We're also very grateful to those sitting behind you in relation to the preparation of the appeal. Now, the board will take time to consider what advice we will, in due course, humbly tender to His Majesty. The court is adjourned. Thank you very much.